In other gun-related lawsuit news, I would have talked more about this in a less dense news week, but so many other things to talk about. This kind of got buried a little bit. Gun manufacturer Remington has now settled a lawsuit with the families of Sandy Hook shooting victims, which, as I mentioned, is very odd because Joe Biden just told me you can't sue gun makers. They're the only industry immune, yet here they are paying out $73 million. How is this possible for that to happen? Well, Remington agreed to settle. It's not this wasn't awarded by the court. It's an out-of-court settlement. But Remington has agreed to settle with Sandy Hook families for $73 million. Of course, Sandy Hook shooter Adam Lanza used a Bushmaster AR-15 to commit this shooting. Remington owned Bushmaster at the time. The lawsuit has been in process since 2015. The lawsuit focuses on how the rifle was marketed. So in some of Remington's catalogs and advertisements at the time, they showed this AR-15 rifle with various phrases, including, consider your man card reissued. So that apparently means this gun is perfect for mowing down your local elementary school. Have at it. Now, I mentioned when I was writing the notes here, as far as I'm aware, there's no demonstration that Adam Lanza or his mom saw any of the Remington advertising or promotional material. That was never introduced.
It doesn't matter, though. It
was never introduced in court. There is no demonstration that they saw the ads.
But it's stuck in the craw of the American zeitgeist, and that
somehow
caused something, yeah.
And it's like, even if his mom saw the advertisement, and that's why she bought the gun. Remember the circumstances of the shooting. He killed his mom when she was sleeping or in bed with a .22 to the head, 4 shots. Then he took this rifle from her. It was her rifle. How the hell does a Remington advertisement mean not only go shoot the kids at school, but kill your mom to obtain this gun?
That's true. Yeah.
That's at least implicitly what was alleged. Now, there's a lot of worry about the precedent this sets, and I don't think that worry is entirely baseless, but I do think that there are some reasons for optimism too. So I'll talk about reasons for optimism and reasons for pessimism. Reasons for optimism. This is a kind of an obscure lawsuit that is based on facts specific to this case. So not just the advertising, which matters here. Not all gun companies are making the same sorts of advertising that Remington did here. I don't necessarily like that as optimism, because what's the conclusion then? Well, every gun advertiser or every gun manufacturer has to sacrifice their free speech rights and walk on eggshells or face liability.
Right.
But it's the advertising angle in combination with particular laws in Connecticut, which apparently make militaristic depictions of guns illegal. I'm not fully clear on what that law says, but as reported here, the family said that Remington's marketing praised the rifle's militaristic qualities and reinforced the image of a combat weapon, which is a violation of Connecticut law. So Connecticut has some sort of specific laws that might be a little more heavy-handed on this. But the point is, it's not clear that this is some broad new vulnerability for gun manufacturers in general. You have specific advertising in a specific state law.
Yeah.
And that's fairly narrow in its implications. So replicating this strategy again, at least this specific strategy, is pretty unlikely. Now, on pessimism, just because this path was narrow doesn't mean the activists don't try to exploit similar narrow paths elsewhere and in different cases. Because make no mistake, this is not about justice, obviously. This is about activists making gun manufacturing unprofitable or a non-viable business due to the liability associated with it. So you now have blood in the water. And even if this is a very limited cut, these activists now know that there's potential to make these cuts in the manufacturers, and they will find them. The lawyers who worked on this case have given statements that imply that as much. It's more about accountability for the industry than it is about, say, any kind of reparation for the family.
Right.
And you might wonder, well, hey, why would Remington agree to settle this? That was kind of my initial reaction. Why would they agree to settle this? Shouldn't they fight the good fight? Shouldn't they fight on principle and not agree to the premises that are presented here? And maybe some people within Remington wanted to go that route, but presumably they did this because they've decided that the cost of paying out these families is lower than the cost of fighting this now multi-year lawsuit and possibly still losing in the end, though they weren't necessarily forecasted or predicted to lose. But Remington also, this may be another reason that this is a little more narrow. Remington is a company that has been it's had a lot of financial problems lately. They've had multiple bankruptcies and pieces of the company that have been sold off. So key point in the settlement of this lawsuit, Remington, it's insurers who are actually paying the, I don't have it highlighted here, but let me see if I can find it. Insurers are paying off the settlement. It's not Remington, the company. 4 insurers for the now bankrupt company agreed to pay the full amount of coverage available, totaling $73 million. So you got to think that the insurers probably had a lot to say about how this case was going to be closed. Yeah. And perhaps more viable gun companies might not be in a similar compromise situation. But, back to the point of pessimism, that's kind of the point, is trying to put as many gun companies in a similar point of financial compromise as possible.
Yeah.
Anything you wanted to say about this one?
No, but this is going to be the first of many, don't you think? Well, it's not the first.
They'll keep trying. I mean, they will keep grasping at straws. I think the only way to fight against this is to get some kind of specific legislation that says, I don't know. I mean, you have on the federal level the protection for gun manufacturers that Biden likes to cite, right. that if the gun is defective or if there's some kind of fault on the part of the manufacturer, that the gun does not work as advertised, they can be held liable. But as far as I understand, that federal law specifically excludes marketing as well, which was another way that they got around this. So perhaps you want to tighten up some of that marketing law. And
it's the video game defense. This doesn't actually influence anybody in any meaningful way.
Yeah. I mean, quite frankly, I'm surprised that law, or the going after people on a marketing basis in this way doesn't have more significant First Amendment implications.
Right.
We treat incitement very specifically under the court's incitement doctrine. You have to make a specific plan at a specific time that has to be realistically doable.
Right. Yeah.
Yet in this case, we say if you just show like a military guide generically, that's enough for us to say that you've effectively incited someone to go commit a crime. There was an article I read.
There's no way to prove causation.
Yeah. I mean, there's an article I read that made an analogy I thought was good. It's like if someone kicked a guy to death and we went after Nike because they said, just do it, which clearly meant murder that man.
Yeah.
This isn't just creeping on your gun rights. It's creeping on your speech rights. And it really should be tightened up, whether we do that through some sort of amendment to that federal legislation or some other mechanism. But yeah, I mean, the assault on both the First and Second Amendments here, I think, is quite significant.